So today I actually have the pleasure to introduce Dr. Raul Sanchez Urribarri. Raul comes as an assistant professor from La Trobe University. He teaches legal studies, right? Yeah. There. And Raul arrived at La Trobe a bit after I left, and during these years we've never really met. So I kept hearing good things about Raul, but never had the chance to meet until I came back to Australia, and now I'm here, so it's a pleasure to introduce him. Raul will talk about the judicial loyalties, assessing the politicization of the Venezuelan Supreme Court. But apart from that, I think it's very important to say that this is a part of a broader project and a book that Raul is writing, where he looks at the politicization of the judiciary not only in Venezuela, but also in Paraguay and Costa Rica. And I'm very excited because I think this is one of the hot issues of Latin America nowadays, including Brazil is facing a lot of issues in terms of changing and imposing controls on the judiciary. So it's a fascinating topic. And before Raul moves on his presentation, I'd just like to say that we all know that talking about Venezuela can be a very sensitive and divisive issue. And I hope we can all participate actively later on the questions, but it was just something that was already planned, and unfortunately the events happened in Venezuela. Chávez passed away, so regardless of our ideological positions on this, I think it is a case that deserves to be looked at, deserves to be broadly studied. And I hope, I'm sure, because I read his paper, and I'm sure Raul will pose a lot of very challenging different perspectives for us tonight. So please, Raul.
That's what I hope, Suleika. Thank you so much. Thank you, everybody. Thank you very much. And I think, Suleika, I think I'd actually replace you in a way at La Trobe, right? As sort of a keeping the Latin American presence there. Let me tell a little bit about my project here, or as we call it, it's originally my baby, because I worked in my dissertation was actually about this very topic, and now I'm working in the process of expanding, on one hand, what the dissertation is about, to include the most recent developments at the Venezuelan Supreme Court, and then also compare or include within the work 2 additional cases, which I'm tossing between Paraguay, Costa Rica, and the Philippines right now, only for comparative purposes, or mostly for comparative purposes. Why did I become interested in this? I'll tell you why in a nutshell. I'm actually a lawyer by training. I'm Venezuelan. From Maracaibo. I have to mention my city's name, whatever presentation I do, as loyal as I am to my hometown. And the reason is, well, when I train as a lawyer, I train at a school considered really good, but which still had a really strong legalistic positivist bent. So I pretty much learned that the law was the main or sole reason that pretty much structures legal reasoning, so to speak. That judges mainly or mostly are the mouths of the law, as Montesquieu once said, and that political / social / economic and whatever other factors should not be taken into account. This is pretty much the first thing in the first lecture on law school. In civil law systems, this is what you hear. Hans Kelsen, 101. Forget about all other meta-juridical factors. What matters is the law. So I graduated thinking, what matters is the law. Now guess what? No. Once you graduate, then you start noticing that the law itself is, of course, a political product. And that judges and other legal actors are, guess what? Political actors as well, which are involved in politics in different ways. And this is something that I came across as I did my master's degree first in law, then I started working at the Venezuelan Supreme Court. In fact, as I see the building, my office used to be one of those little windows up there. And I spent 5 years there, and this time actually was very challenging for me intellectually in terms of questioning those core beliefs that I had learned very well as a law student. And all of a sudden, okay, what's going on? Why is the court playing such an important role? I mean, I spent 5 years there during the beginning of the 2000s, right when Chávez came into power. It was a very interesting time, a time of change, a time of very exciting changes, time when, of course, the country was going through a lot of through struggles in a way. I think it was a struggle of identity, and we can talk about that if you wish. But in terms of the in terms of what it, I think, in terms of the implications for our notion of the rule of law and what the role of the law was for the purpose of structuring state-society relations, for constituting state behavior, and ultimately to serve either as a constraint or an enabler of political action, were actually quite sensitive with very important issues. So to make a long story short, while I was there, I began thinking, well, what is exactly motivating or driving judicial decisions, especially when it comes to politically salient cases? Why are the judges behaving this way? Why do they form a coalition, a stable coalition for a while, and they break up? What are the implications of what I'm witnessing in terms of the political involvement of different factors and actors on the court? And this, this actually propelled me to leave the legal profession and become an academic, honestly, which is one really good outcome. I love being an academic, I really do. And as much as I respect law and the legal profession, I don't really have an intention of going back to legal practice. But it also, I think it also, drove me to do a PhD. I did my PhD in the United States at the University of South Carolina. And from the very beginning, I remember the first conversation with my advisor, hey, I want to understand the Venezuelan Supreme Court. And he said, no, if you're going to study here, you want to understand courts, and you want to understand courts as political actors, and you want to understand politics. That was cool, because that meant, of course, going into studying for a long time before going back to analyzing this case. And you will see that my talk, I think, reflects those concerns, I think, a genuine concern for the rule of law in Venezuela in the best and intended way. At the same time, theoretical concerns that I'm going to try to convey both to the scholar academic audience and the non-academic audience. You will see more or less what exactly is what I'm interested in. Having said that, we have a lot of stuff to go through, so I'm just going to breeze through the slides in sort of the most, not cursory, but probably in the best possible way. So we have, pretty much we're going to have a bit of a discussion on the connection between politicization of the courts and judicial power and why that matters. And then talk a little bit about what are political connections in the context of Latin America and how that shapes judicial decision making, especially when it comes to prominent or important politically salient cases. I'm going to talk a little bit about the theory and research design, which is something that we academics tend to get a kick out of. And I'm going to make it engaging in such a way that you can see more or less what pretty much my days and nights for a while were about. Then we're going to talk about the real thing. We're going to talk about the Venezuelan judiciary, give you a little bit of the historical perspective. Why is the Venezuelan judiciary, where are the roots of the weakness in terms of political weakness of the court? We're going to take a look as far back to the 19th century. Then we're going to start moving all the way to the 20th century. Believe me, this is not going to take the tone of, okay, so this was 1848. No, don't forget about it. It's going to be dynamic. We're going to land to the last 20 years, and I'm going to offer you some qualitative, but mostly quantitative evidence of the politicization of the court before and after Chávez's arrival in power. And lastly, we're going to talk a little bit about the implications, both research-wise and also for Venezuela in a practical sense. So tell you a few things about why this matters academically. Now, a few things. First of all, there's been, of course, an expansion in the past 20 years or so, especially during the third wave of democratization. I'm talking post-1990s here. There's been an expansion, what is referred to as an expansion of judicial power, or judges have become more prominent as political actors. In Australia, you probably remember, of course, the Mason Court years, years in which the High Court became a prominent political actor. And later on, pretty much, even if the later years didn't match the activist, so to speak, years of the Mason Court, it still solidified or strengthened the High Court's role as a political actor in the Australian political system. However, of course, these were very interesting developments in the case of Latin America as countries began transitioning away from dictatorships and authoritarian rule. The possibility or the intention of having a strong judiciary, of course, became key, especially to prevent governments from abusing their power. That was the main concern. And one of the ideas was within the framework of liberal democracy was to, let's create independent judges who are principled, well-trained, and hence have the power and the intention to control the government, especially when it comes down to abuses. However, the thing is that, of course, these changes don't take place in a vacuum. And as we know, for example, those of us who are familiar with how neoliberalism worked in Latin America or failed to work and all the problems that it involved, I'm not going to talk too much about that, but we do know that whenever these recipes are applied in a context that already has certain patterns going on, the other results are not necessarily going to be the ones that are intended. And this is what happened. Truth is, in Latin America, even if judges and courts in general have become more powerful, in many countries they are still heavily perceived as politicized. And this, of course, prompted some of my research questions, and especially, what is this politicization about, and how do we assess it over time and across space, across different countries and over times? And of course, what does it mean for democracy in Latin America, and specifically in countries that are undergoing processes of change or processes where liberal democracy, as it's understood, is being challenged? So that was pretty much the central goal of my work. And the key case to understand this politicization was Venezuela. It has nothing to do with the fact that I'm Venezuelan. Of course it does, to some extent. It's the country that I'm most familiar with, but also it's a unique, very interesting case, underexplored, understudied. At the same time, Venezuela had been a democracy for several decades before the current changes were witnessing, and a democracy with a number of failures as well. So it made it a really interesting case in that respect. So of course, if you want, you can say, Venezuela, a country that quote-unquote transition from quote-unquote democratic rule to quote-unquote hybrid regime. And if you want, we can talk about that later, what each one of these labels involve. The point is that the country did experience a transition from one form of expressing and articulating democracy to a different one under Chávez's rule. And the key premise that I pretty much witnessed, and this was rooted, I think, partly in theoretical, once again, as I began reading more and more about the theory, especially in the context of judicial politics in the United States, where, as I'm sure many of you know, the US Supreme Court is a key political actor in the United States. If you, for example, follow US news, you're probably familiar with the fact that the Supreme Court, for example, decided a huge case with the so-called Obamacare plan to make healthcare accessible to all Americans, pretty much. And once again, this is one case of many that the court decide on a yearly basis. The court has been a very important political institution for centuries already. And of course, in this case, in the American model, the key reason, or the key, pretty much the key assumption, is that judges decide, at least from a political science point of view, judges decide on the basis of policy preferences and ideological proclivities. And this is pretty much, let's talk about this sort of straw man that I was running against in my dissertation. In my case, I said, well, look, ideology matters, but there are additional ways of structuring political action that are not being captured by this way of analyzing politics. In Latin America, personal connections matter. And in Latin America, the informal dimensions of politics matter. Some of these are rooted, of course, in quid pro quo arrangements, which in the case of political scientists, under clientelist arrangements. Others are forms of identification that transcend the material-based agreements. Simply, you are identified with a group and you're going to do whatever it takes to defend your group. And guess what? When judges are appointed in several countries in Latin America, these connections matter. But that's exactly my argument. These connections matter for a reason. And it's part of what Kapicesky calls in a recent really good book called The Judiciary's Character. And as I began researching, I noticed, oh wow, this is not something that I'm dreaming. This is rooted in Venezuela's history. You can clearly see how this somehow is rooted in the way the country's judiciary worked for a really long time. So a few questions. Where do this connection between political actors and judges come from? So this is something that I try to explore historically. how do they influence courts' assertiveness or submissiveness vis-a-vis other more powerful political actors, and especially, of course, the executive branch. And this is not only in Venezuela, in most of Latin America, traditionally, the most important actor is el presidente. And that's been the case for centuries already. How does this impair the emergence of the rule of law, or affects the emergence of the rule of law in one way or the other? In that sense, the basic premise was, well, judicial loyalties condition the judge's ability to challenge the regime in key political issues in a variety of ways. Every once in a while, of course, I have to offer a nice picture to take your eyes outside from reading so many letters so quickly. That's actually the largest stained glass in Latin America. You see a proud Venezuelan talking good things about the Venezuelan Supreme Court, and it's true. It's a really cool building, and that's a really cool stained glass. And this is actually a picture. As you can see, it's a pretty disordered stained glass for talking about justice here. But cool thing is what you don't see here is Simón Bolívar right in the middle, which is pretty much keeping a balance between order and chaos. And that's pretty much the role of justice. So it's a quite symbolic building, which I understand as the tension between formal and material justice. Now, some of the background literature. Some of the things that some scholars have studied. I'm not going to spend too much time on this, so we have more time for what really matters for let's say, the steak and potatoes of the presentation. So on one hand, of course, courts within liberal democratic models are seen as a check on political actors to hold them accountable and uphold the rule of law, so to speak. And of course, connected with this is the notion of separation of powers, which different countries in the West, in Western liberal democracies, have different notions of. Some stricter than others. Another interesting division is, of course, the discussion of judges as legal operators versus political actors. And lastly, really nice, interesting stream of literature looking at judges as agents of the regime, pretty much, and looking at their behavior and to what extent they represent the visions or views of the current governmental coalition. And this is pretty much what prompted earlier works in what we nowadays call in American political science literature, judicial politics, like Pritchett's analysis of the Roosevelt Court, Dahl's analysis of strategic decision-making at the US Supreme Court level, and so forth. And later on, of course, to make a long story short, there was a stream of works, 1980s onwards, looking precisely at this connection, both qualitatively and quantitatively. And the main three models that emerged in this sort of literature, especially in the 2 or 3 last decades, are the attitudinal, strategic, and legal models. The attitudinal model is, in a nutshell, is judges decide on the basis of their policy preferences. I'm going to do what my beliefs. I decide the way my beliefs tell me to. Then there is an additional literature that says, hey, wait a second. You have those beliefs, but you take into consideration the surrounding political environment, the preferences of other actors. It's not that you are speaking your mind honestly here. I mean, you anticipate the consequences of your judgments. That model is the strategic model of judicial decision making. These two models are in a way connected to a trend in those of you who have received legal training. You've probably heard about legal realism. These two models are connected to legal realism, whereas the legal model looks at the law role in a sort of a different way and says, well, look, the law is important and structures is the key determinant that structures judicial decisions. And it can serve as an enhancer or preventer of judicial power depending on the circumstances. And there are a host of other accounts that I won't mention for the sake of time. My contribution in this respect is to try to improve on this model's applicability to contexts where once again, policy preferences are not necessarily the key or only structural factors in political life. And in that sense, you will see that that's one of the bridges or connections between these streams of work and my work. Second is, of course, sort of an institutional related literature that connects to, on one hand, speaks about judicial empowerment and mostly about under what conditions judges become powerful actors, or more interestingly, under what conditions are politicians willing to let judges or assign judges the role of becoming powerful actors. And there is a number of little scholarship streams there, once again, that I won't elaborate on for the sake of time. And other related interesting topics, judicial independence, the difference between judicial independence de jure and de facto, or mainly, most constitutions around the world talk about an independent judiciary. But guess what? Countries vary widely when it comes down to actually seeing those courts as independent actors. So there is a distinction between de facto and de jure independence. And lastly, questions related to the conditions under which courts become powerful. And in that sense, there are a number of interesting theories, including, of course, to what extent this is a circumstance or a consequence of the judge's own plans or deliberate intention to become powerful. We're going to be a powerful court because that's what we want to. Or because, for instance, or because the political scene is fragmented. So, hey, legislators are fighting with each other. They need an arbiter. Guess what? Come here. Here I am. I can solve your problems and, and gain additional power. A number of other factors, institutional arrangements, dealing with the degree of openness of access to the courts, the ability, the relative powers of the courts, jurisdiction, and so forth. And lastly, other series of works looking at political context, the role of civil society, social forces. So as you can see, it's a pretty rich literature here. And I can tell you really interesting things to read for a long time. So my PhD in that sense wasn't boring at all, honestly. It was really cool. And this is some of the practical pictures that that I remember seeing and thinking, well, look, for example, the camaraderie between President Chavez, rest in peace, greeting Omar Mora, who was back then president of the Supreme Court. And by the way, that lady who's looking right there and smiling, between the two of them, became Chief Justice later. I think that pretty much what she was saying is, I'm next, buddy. She was next. She just lost her position 2 weeks ago to another woman. So, against this literature, what is my argument? Why do courts vary in their ability to uphold the rule of law? And what motivates judges' behavior, especially in politically salient cases? The main proposition is that the judge's ability to control other political players is contingent, all the factors equal, on the existence and persistence of important links with political actors, on whom they depend for the purposes of reaching and keeping office, and ultimately enjoying the benefits associated with their post in a variety of ways. Whether we go into what this involves in terms of corruption or not corruption is a different thing. To what extent all judges or most judges or some judges is actually are actually appointed this way is also an empirical question. Now this is the theoretical proposition. And at least my prediction with respect to the Venezuelan case is, okay, let's see to what extent this sort of embedded patterns of judicial loyalties and political connections explain the Venezuelan judiciary's chronic weakness vis-a-vis political actors across different types of regimes. And in that sense, I define loyalties pretty much as commitments made by judges to individual and collective political players. One of the challenges of my dissertation, certainly in terms of and of the books, by all means, is of course defining and establishing the relative strength and presence of these connections. And certainly it has a lot of more leverage when you look at the individual decision-making basis. I also hypothesize or theorize that this had an impact with respect to the work of the Supreme Court as an institution overall. And lastly, was trying to drive the point that this was definitely different from ideology. And among other things, some of the sort of the basic theoretical propositions that I exposed. One was, the influence of political loyalties on appointments has a negative effect on the development of an influential judiciary. We'll talk a little bit about that. And ultimately, the existence between a loyalty link between a judge and a political actor will pretty much drive or will be a powerful incentive for the judge in question to decide in favor of the said political actor, ceteris paribus, and even taking into account other control variables. And I assess this through both quantitative and qualitative methods, as I'll explain in a second. And by the way, please feel free to stop me if there is something that I need to clarify, or because I know that I'm trying to go as quickly as possible And it's feeling okay so far. But if you have any question, let me know. So how did I pretty much face this monster, so to speak? I did it in 3 different ways. I look at it historically, pretty much looking at the history of the Venezuelan Supreme Court and where the judiciary was coming from. What are the origins, or as some scholars would say, the court's character. It was one thing. I said, okay, in order to know more about this, I'm going to have to read a bunch of things about the Venezuelan Supreme Court in the past. I was really lucky also that while I was at Tulane University working as a visiting assistant professor and working my dissertation at the same time, I came across, I don't know how, Tulane received copies of the decisions of the Supreme Court from back in the late 19th century. And I discovered this just by coincidence at the law school, and I was very, very bored that day. I was like, here, this is a gold mine. So I spent like 3 weeks looking at those decisions from back then. Gave me a lot of information about how the court worked. And even if I didn't systematically document them, well, the decisions are there, and they survived Katrina. So I'm happy to go back and see them again if I can. So we're going to talk about that, and then we're going to talk about the role of the court in 3 different stages. Briefly, during the times of quote-unquote stable democracy, then the times when this so-called stable democracy went down the drain, so to speak, and then literally when the transition to what I call a hybrid regime, but let's call it Chavismo, happened. The focus was on constitutional review cases, and the test was both qualitative and quantitative. The quantitative part involved coding and systematically coding across a set of variables. I think it was about 40 or 50 variables. If I recall correctly, it was about 80 cases for the Supreme Court en banc, which is the plenary chamber of the Venezuelan Supreme Court. That was throughout the 1990s. And then database of, if I recall correctly, 437 cases between 2000 and 2009 in the Constitutional Chamber, which should be increased to about 550 once the database is complete with 3 additional years. That's pretty much the court as it used to be. It's a beautiful, old, small, unimportant building. And this is, of course, that was the headquarters, I think towards the end of the century, then throughout the beginning of the 20th century, for a long time, until that huge building you saw were built. It speaks, sometimes buildings speak volumes. And I think that speaks to the lack of relevance, so to speak, politically speaking, of the court. It was mostly conceived of as a legal institution, Court of Cassation, as is referred to. I'm going to just briefly summarize pretty much what we see, especially at the beginning. At least when you start looking at the historical roots of politicized courts, there are a number of things that you really have to look into, especially if you're interested in several countries. Things like, for instance, understanding who the key actors were, what were the different political interests and mechanisms that make this sort of judicial loyalty significant. And of course, this also involves in getting a basic understanding of some institutions in the right way. Understanding the rules of appointment, the main characteristics of the judges, a basic idea of who these folks were over the course of time, some basic institutional features of the judiciary. There are scholars who look into the social background of the judges, all sort of things that gives us a picture of what the courts looks like and why. And there are 2 basic eras, so to speak, in Venezuelan judicial history. One is, of course, broadly speaking, the times of the dictatorial years, although that is directly connected also to the evolution of the Venezuelan state. If I had to be a lot more careful with respect to the evolution and different stages, of course, between 1830 and the 1870s, it was one period, then 1870s, 1910 was another period, 1910, 10-ish, 1958 would be another period. Democracy, there would be 2, 58 to 89, that's 88 to 99, quote-unquote democracy. And this was a period, of course, of high institutional instability. Venezuela has had 26 constitutions and counting. Because even if I believe that the current Bolivarian constitution is not that bad, I do think that it's not going to be the last one. It's going to be, this is pretty much a prediction based on past record. It's got 26 boyfriends so far. There's another one coming around. Then, 1830 to 1958, these were times of Venezuela under military rule. This was a time, of course, in which during the course of the 19th century, there were a series of key issues that defined Venezuelan political life, which also influenced courts. Caudillismo, for that matter, of course, in that time, whoever was the powerful caudillo was the key political actor. Politically irrelevant courts, so to speak, in the sense that these were courts that were mostly dealing with legal issues, for the most part. And then case law shows a Supreme Court focus on economic cases. That case law I was telling you about that was really cool, was mostly economic cases, for the most part. Very few politically related cases. And these economic cases had something to do with the very limited, narrow aspect of what the state was about back then. So if you want to speak about political, to some extent, clearly not in the sense that we speak about today. Then, of course, in the early 20th century, as the state begins expanding its action, there are two parallel developments. One is increasing professionalization of the courts. And the courts start becoming more and more relevant to adjudicate and solve problems and questions. On the other hand, as judges start becoming more and more relevant and more powerful, politicization begins as well. In the sense that, of course, they start becoming more and more important and prominent. And there are all sorts of reasons that we can think of why this is important. Well, to begin with, judges are making decisions that are more significant for the Venezuelan state. On the other hand, they are also commanding more resources. So there are all sorts of reasons why this made the courts particularly vulnerable to political intervention. And in fact, the first completely open intervention from the executive branch in terms of politically controlling the courts didn't come under the years of democracy. It was actually before. It was with the times of the so-called Justicia del Ministro in the 1950s. It was an attempt by the last dictatorial regime we had in the 1950s to control the judiciary, pretty much, and pretty much put the key judicial appointments on the lower courts on the hands of the Ministry of Justice. It was pretty much, and it was a major move. It was pretty much put the judiciary under the hand of the executive branch. And once the dictatorship comes down in 1958, and a sort of a limited democracy based on mostly based on political party and political party elites come around. 10 minutes, which that means I'm going to have to jump a couple of slides here and there, but I'm still going to give you the picture right away. Long story short, 50s, 60s, and 70s witnessed the increasing politicization of the courts. That's what happened. And as courts, once again, as the regime became democratic, there was a need for legitimacy that, of course, made courts more prominent, but they also made it more vulnerable to political intervention. And I think probably the key event came in the late 60s, early 1970s, when the ruling party, Democratic Action, lost power for the first time. And guess what? The Justicia del Ministro no longer worked because the executive branch was going to be in the hands of the opposition party. So all of a sudden, the party discovers the virtues of moving the prerogatives of appointed judges to a judicial council. Oh, guess what? The Constitution talks about a judicial council. Let's not put the judicial appointments powers in the hands of the ministro. Let's move them to an autonomous body. An autonomous body that happened to be the hub for political negotiations between the two main parties. So essentially transfer the appointments from the executive branch to the political party elites. And the judges became increasingly or decreasingly less professionalized. And in order to get an appointment, you knew that in addition to be a good lawyer, or in addition to be a good judge, you needed to have the right padrino, you needed to have the right connections, which usually meant having a white or green political card. Acción Democrática, Democratic Action, or COPEI, like the one my dad had for COPEI for a long time when he was a professor at the university. And he was quite autonomous in what he was doing, but it was the way that things worked. That was Venezuelan democracy before. Not strange for a number of countries around the world, by the way, for many so-called liberal democracies. This is how the judiciary was structured. And this, of course, meant completely politicizing the court system. Did this mean that there were people who had a strong sense of professionalism? Of course there were. just as there were many professors, like I think my dad, who was very committed to doing the right thing. But of course, you still had to govern, you still had to sail through a highly politicized environment. Problem is that this didn't last forever, as we know. As the regime began to crumble, especially in 1980s and 1990s, due to a variety of problems, especially on the economic side, high corruption, lack of legitimacy, and so forth, major social problems, riots in 1989, coup d'etat by a new guy around town called Hugo Chávez. Then, of course, Venezuelan democracy began collapsing or began having troubles to gain a sense of legitimacy. And that's how we arrived to the years of the Venezuelan Supreme Court between 1989 and 1998. In this deterioration, during this time, by the way, these were the years when I was training in law school. And I remember thinking, no, Supreme Court justices, they are so autonomous, they are quite courageous, they're actually able to decide against political actors, because that's what we are supposed to read and understand. Well, what I ended up noticing is that an influential judiciary at about that time didn't emerge. Even if the political scene, the political control of the main parties was collapsing, even if there were a number of changes that suggested the emergence of a powerful court, that powerful court never happened. It was one of the things that surprised me while I was doing the dissertation, because I wanted to see otherwise. I thought, even if it ran against my theory, because as powerful as beliefs are, right? It's like, gee, but this court is supposed to be powerful. What am I seeing here? What I saw was actually, I'm going to jump this slide to show you some of the cool stuff because we're running out of time. In the 1990s, the major ruling party, Democratic Action, lost control of the court. So one of the predictions that I wanted to assess is to what extent the opposition or the ruling party were able to use the court for the purposes of, of exercising power. And it made sense from a number of theoretical perspectives. So I created a quantitative model based on a series of variables, looking at the relative effect of the presence of both opposition and AD ruling, or past ruling party, and controlling for a series of factors that would be relevant based on the judicial politics literature. A summary of these predictions is actually here. So if the case is filed by ID-affiliated actors, for instance, if the court was in the hands of the opposition, then you should be a sort of a negative or less inclined to decide in favor of this actor. If it's an opposition-affiliated actor, it would be more inclined to decide in favor of this actor. And then a number of this is the minus and plus signs here, the key independent variables. And these are some of the control variables. If the case is filed by the Attorney General, given the fact that the Attorney General is actually a prominent legal actor with really significant expertise, it's positive. If the case is against the executive, don't mess with the chief executive, it's negative. If it's a national case, the courts are going to be less inclined to decide the case against the law or striking down the law, because of course it's a case of high prominence. If the case is a total annulment, meaning striking down a law completely passed by Parliament, well, the court's going to be less likely to decide it, because once again, it's an exercise of power that goes beyond the usual, or it's too extensive. So these were more or less the control variable. These were the control variables. These were the two key independent variables. And again, what we're trying to assess is how these different variables explain whether the court is willing to exercise its constitutional review power, namely striking down legislation or an act of Parliament for 1 or against 0. Okay? This is more or less how it makes sense. Following me so far? Okay, let's go to two things. The horror. When I saw this graph, I said to myself, okay, 2000 is the year when, 1999 is the year when Chavez comes effectively in power. This is just looking at the number of constitutional review annulment decisions per year, before and after. Before is like, please don't make me decide these cases. Actually, there were a number of cases, when I worked there were a number of cases that gathered mold. When I read those cases, I had to wear like a special mask and stuff, because they were in a special, division, and don't go in there, no, don't worry, go in there. Now we understand why. They weren't deciding cases for the most part. They were documenting. They didn't want to face the political actors. They preferred to just, whatever hot potato, so to speak, in a political sense, put it in the drawer, as we say in Spanish, engavétalo. There were a number of engavetados cases. This speaks of a different type of Supreme Court, especially in the first period. A bunch of those cases are engavetado moldy cases, especially in the first few years. But then, as time passes by, after 2002, they smell fresher. We had the cases that came to the court while the two groups, Chavismo and the opposition, were fighting. And then, of course, decline as Chavismo seizes control of the state. Now let's go back to our model. Remember, key predictions. Let's see how our model works. And here comes the dreary and usually fearful numbers. But the important thing here is to see, and guess what? Some variables worked, some others didn't. It was a mixed picture, so to speak. If you were with the opposition, it did lend some support to the idea that if you were affiliated with the opposition, you had like at about a 4 times higher. This is pretty much what it means. I mean, this is a logic model, so these are odds ratio. So it's 4 times higher than average chance of winning the case, so to speak. Okay? But when you look at the number of cases, it was really small, anyhow. So that number is, to some extent, is misleading. With respect to democratic action, however, the ruling party, PET-AD is the ruling party, or the traditional ruling party. PET-OPUS, the petitioner, is the opposition. And you can see the difference there. The first variable, the first result, suggests a 6 times higher proportion than usual of winning, but the case didn't come up significant, which is what the little star means. Which means that we can't really trust that this is actually the case with a sufficient degree of confidence, so to speak. The case of the opposition, we can to some extent say that yes, it is more, it's more trustable, so to speak, or trustworthy. There were a number of other variables that were really interesting. By the way, one that is really cool is to see the national variable, which is when the case is national, courts don't really want to mess with a national exercise of legislation. They don't want to mess with Congress. They are 5 times less likely to strike down legislation if it comes from the federal government and it's at the national level. It's like, please don't bring those to the court, pretty much. A finding that you will see that continues afterwards in the years of the Venezuelan Supreme Tribunal. And pre-salient is a variable I created of salient cases. Salient cases are cases that are politically relevant. These cases, I measure them looking at newspaper records for about 12 years of 3 major newspapers, systematically looking at the front pages of each one of these newspapers. And I tracked down each one of these cases, so to speak, created an additional database, computed those. Guess what, once again, if the case was salient, engavetado. Put it in the drawer. If you have to decide it, against. Once again, a coward Supreme Court, so to speak. If I have a few minutes, I want to jump 4 or 5-ish. Okay. Now let's see how this court compares to the court under Chávez's years. The court under Chávez's years could be an additional talk in on itself. Really cool period, really interesting. There is the traditional assumption that the Supreme Court under Chávez has been dominated by Chávez. Not true. It's a mixed story, and it's a really more complicated story than many people think it is. It involves different periods depending also on how Chavismo functions. It also involves different roles for the Supreme Court depending on specifically the needs of the state, and certainly the connection between Chávez and the court, and especially the justices themselves. But just to compare a few things, to highlight a couple of things. The Supreme Court under Chavismo is actually the Supreme Court as designed in the 1999 Venezuelan Constitution. It's a much more institutionally powerful court. Excessively open, very powerful institutionally speaking, with powers to strike down legislation of all sorts. And in the first few years, originally with 5 justices, especially the Constitutional Chamber. This Constitutional Chamber, we call it in Venezuela la super sala, which literally means the super chamber, because it has the ability or prerogative to strike down not only legislation, but even the decisions of the other sister chambers, including the plenary chamber. So essentially the most powerful, the big kahuna in the Venezuelan legal system. The major change during the time of Chávez's years came in 2004. precisely before the referendum, 2003, 2004, the regime saw a need to control the court. Did away with, expanded the Supreme Court and appointed justices who were closely aligned with their political project to prevent the court from effectively becoming an opposition hotbed, which is what somehow had become until that moment. These are some of, those of you who are interested in the court, there is additional information here and data about who the justices were, how they, how professional they were. Look at, most of them have doctorates, most of them had, at least half of them had judicial experience, others who were prominent professors. These were, for the most part, highly respected people, professionally speaking. For the most part, not all of them. I remember at least two who weren't, honestly, but anyhow. Now, looking back at the trends, this is for example, some numbers. That's the number, for instance, of constitutional review cases, sort of mirroring the other graph that we saw over there, sort of including also amparos filed directly against prominent political actors. Once again, symbolizing that, curve, going after the bell-shaped curve after 2000. So a genuine growth under the Chavez's years. Counterintuitive for many people. But with respect specifically to what extent we witness the politicization of the court system, once again, we run a very, very similar model, this time with more variables. So I could actually add a couple of other variables here and there to make it more interesting. Now, analyze whether the case was filed by a pro-Chavez politician or governmental actor, case filed by the opposition with negative. Of course, if this is pro-Chavez, the idea is, well, with the court being dominated by Chavista allies, should increase the likelihood of ruling in favor of the petitioner. If you are side with the opposition, then the odds of winning are, of course, lower. That's the assumption, right? The main prediction. Then, if the case is against pro-Chavez actors, the other way around. Prediction is negative. I'm going to protect my people. Cases against opposition, guess what? It's positive. Let's go against those opposition guys. Let's see what happens. And then you are familiar already with these bodies here, the control variables, to see whether these other control variables accounted for also for the variation that we witness in terms of whether the petitioner is favoring the court or not. And here I added another couple, or made a bit of a twist because of a modification of the system. If the case is against the citizens' branch of power, is filed by the citizens' branch of power, which is a branch of power that includes the ombudsman, the attorney general office, and so forth. You're familiar with the key prediction, and here comes the result. Ta-da! So cool. I was so happy to see this. From a scholarly perspective, it's really cool. It's really interesting. Look at this. If you're a pro-government petitioner, 4 times higher the proportion of winning cases. 3.9999. Those stars is significant, highly significant, in fact, statistically speaking. One can be very confident that this is actually the case. If you are, for instance, an opposition petitioner, 3 times less likely. You can also be confident in statistically, you can have high confidence that this is actually the case as well. You remember when we talked at the Supreme Court in the 1990s that the national level was a key factor, driving whether the court was willing to exercise its power or not? 10 times less likely to decide against a petitioner. Once again, when it comes to national prominent cases against the National Assembly, the court thinks not only twice, thinks 10 times more, pretty much, before striking down legislation or acting on behalf of the petitioner. If the case is, for example, a total annulment, again, it's less likely. It's more likely, more willing if you're going to strike down only a small provision or some select provisions of a given act than the whole statute as a whole. And again, another cool one. If you're a petitioner with a Poder Ciudadano, if you're the Attorney General, if you're the Ombudsman, you're going to be more likely to be favored at the court level, which is lends statistical support to a well-established hypothesis that I think by now travels very well across nations. This is something that we tend to discover or see in other countries as well. So this is pretty much, by the way, before I finish, an additional twist. This is disaggregated by different types of proceedings. Amparos are urgent cases, sort of interim relief cases. When I began running the models, I noticed, okay, if you're a pro-government petitioner, guess look at how high the number is. The court is 6 times more likely to decide in favor of the petitioner. But if you are with the opposition, look at what happens. Well, what happened is I began running the model, computer froze. Began running the model again, computer breaks down. I start looking at the data, what's going on? Of course, no cases in favor of the petitioner. Namely, the opposition never won an amparo, zero, niche, nada, at the Supreme Court during Chávez's years, at least during the years that I examined at the High Court level, directly at the Constitutional Chamber level. Which of course drives us to another question. Why would they then file in these cases to begin with? That's a very important question. Well, sometimes you get political prominence only by going to the court and filing a case against the regime. In other times, at least from talking to opposition lawyers, what they would tell me is, hey, no, we have to build a record here, a record of violations. And even if the court is Chavista, I don't care. In the future, this will be a track record that we can appeal to or resort to talk about how authoritarian the regime was. That's at least what they explain. For the sake of time, let me just go into some conclusions. With this, I hope that I have given you a snapshot, pretty much, no, sort of a broad historical perspective of why the court was politicized, how it was politicized before, not right now, to what extent it was politicized and in what sense, how right now, especially in the past 10 years, has effectively become politicized and in a very bad way. What are the implications of this politicization? That, of course, is very important in and of itself. For Venezuela right now, and this is probably the only mention I want to make with respect to the current situation, one of the key problems that the government is facing, not only the government, the country is facing overall, is the deterioration of certain institutions that function as a check on political power. Decaying professionalization and growing politicization. Whether we want to agree with how benevolent or how good this is and to what ends is different. But one of the problems, of course, then happens when you need a court that effectively can shepherd the country in the direction of within the framework of the rule of law. But then these commitments to a political cause prevents it from playing effectively this role. And as a result, the court, I think, has suffered not only the lack of legitimacy from the viewpoint of the opposition, but even from the viewpoint of the government itself and government supporters, is seen as an additional branch of Chavismo and not as an autonomous institution. I'm not saying, of course, that this is necessarily going to be the last situation, even within Chavismo. We've seen countless situations in which a regime sort of notices all of a sudden that strengthening the independence of the courts is important for the purposes of restoring legitimacy. That might well happen. It's happening in other regimes, for example, with the characteristics of Chavismo as well. But that's something that is still yet to be seen. In the meantime, there are a number of things that I want to do. I want to extend the database. I want to keep doing my quantitative part. I didn't give you a number of, an analysis of the cases themselves. But if you want to ask me by email or talk to me over coffee or any other thing that makes me talk, believe me, I'll be more than happy to illuminate what those numbers mean in practice. But as you can see, I hope that the numbers have conveyed a story, a very interesting story. And of course, as we usually say, whenever I finish the story and I add the qualitative cases right there in writing, please buy my book. Thank you so much. Over the course of the last 20, 30 years, the judiciary has been increasingly populated with women.
Yes.
And out of the last 5 chief justices, 3 have been women, including the current one, the new one who was just appointed last week. And it's very interesting. However, they still don't form not even a majority or not even half of the Supreme Court. They still have some gains to make in that sense. Same thing happens with the legislature, but the trend is significantly positive. And it was already happening from the times of the partyarchy years, for the times of the previous regime. I think it speaks about, if you ask me the main reason, I think it has to do with the fact that if you go to Venezuela's law schools right now, my guess would be that 60 or 70% of the graduating attorneys are women, and also the best students. Yeah. if I may tell you, it's once again, the labels, as you can imagine, I made on one hand a long story short, and of course I had to simplify the use of some terms that per se are controversial, and I recognize that. I think that we can talk, as extensively as you want about the conceptualization of these periods and the empirical implications of them. I do think, once again, and it's a matter of of theoretical assumptions and then of empirically thinking about what this means in terms of what each one of these labels convey. If you ask me, for instance, I do think that the period between 1958 and 1989, and I'm saying 1989 because in 1989 the Caracas riots, the Caracazo happened. So I think and afterwards the regime was severely questioned in terms of legitimacy and in terms, of course, of the lack of governance that ensued over the course of the 1990s. However, what we can't contest is the fact that for 30 years in Venezuela there was at least a basic consensus around electoral institutions functioning and delivering results, even if, of course, they were still marked by occasional episodes of fraud and so forth. These were elections in which the left also participated, especially after the 1970s. The left came to power in Venezuela in different forms, came at the local level, at the subnational level, and ultimately, thanks to the coalition with Caldera, came into power before Chavez came in power. And Chavez himself came through elections in 1998. Now, what we can't say for sure, and this I want to say for record, because it's still to be proven, not because I'm saying anything about it, is whether an opposition victory would be recognized in Venezuela. That's something that, of course, is a matter of different debate. What I'm trying to mean is it hasn't happened so far. Look, the only election that the opposition won, we never knew the definitive results in numbers, and the president called it a shitty victory. And not Chavez, the president, because I don't refer in this case to him as Chavez. It's the president. I don't want, of course, to argue additional things. And I recognize every single victory that Chavez ever had. And I consider him the constitutionally elected president of Venezuela, and in that sense, my president. Yeah, I mean, it's a topic, look, this is a topic that is very hard to speak, especially from the viewpoint of a Venezuelan. Because what really pains me is to see how polarization has penetrated academic discourse. To the extent that it's really hard to speak about these issues in an objective fashion. It's very hard. I'm offering a partial view, and once again, from the very beginning, I remember that at some point in the discussion I said, it's a mixed record. The things that none of the parties on both sides of the spectrum want to hear that it's a mixed record. That's the problem with polarization. It's a mixed record and makes it significantly difficult to convey. That's the problem. And of course, it's natural that with a highly charged, sensitive issue like this, whatever position you take is going to immediately prompt strong opinions. I've shown this research to people who are strong opposition people. And you have to see, for example, the things they've told me about what my findings with respect to the 1990 Supreme Court. That I'm selecting, that I'm handpicking my cases, I mean, all sorts of things. But of course, in this sense, it's just an additional reflection of the major dragon or enemy that I think some academics or scholars are trying to fight against. We will, wittingly or unwittingly, contribute to this polarized discourse as we study Venezuela. But it's the nature of the beast right now. I think the best way to actually approach it is at least grounded in actually empirical data, which usually tends to produce these mixed results that make a lot of people uncomfortable because they don't fall squarely into the two prominent discourses. If that's what happens, if that's what happens, I'm happy. No, that's a very good point, and that's why I made a distinction between run-of-the-mill cases, not so important cases, and highly politicized cases. That's a very important point and a fair point.
I think that
there are many cases that are, for example, there are a number of
cases.
cases that are, for example, non-political at all,
These
or
very
less political.
Very political.
These
but
are-
they don't fit into your
These are all, for example, heavily political. These are all heavily political, ranging across a number of issues. I actually coded the types of issues as well, which is very important to see. What I'm trying to convey, and I'm telling you to the both of you, is, guys, I'm going to the greatest possible length, not offering a biased view of what happened.